Afternoon, everyone. This is Kristen. We'll get started right at 1 o'clock. Thanks. Good afternoon, everyone. It's Kristen. I am just logging on, getting started. Hoping everybody can hear me. If not, I'm sure you'll let me know in a second when I start to switch slides. Last time I know somebody shot me a note saying that everything was okay, but then I was getting other notes saying they couldn't hear me, but as long as one person can hear me, I'm assuming things are good on my end. So today we're going to do an overview, and excellent. Someone just sent me a note saying they can hear me, so I'm going to keep moving along. Thank you. Okay, so today we're going to do an overview, or this afternoon overview and update on the New York State open meetings law. Somebody joined me this morning, and that was great for the same thing for the Freedom of Information law. So very few things will be crossover, but most will not. Up on the screen right now is my contact information, or the contact information for the office in general, because we're a tiny little office. So our website is www.opengovernment.ny.gov. Our email address is coog@dos.ny.gov, and phone number 518-474-2518. Call that number, send an email to that address, and the first attorney that has an opportunity to do so can get back to you with answers to your questions. So here's our website. On our website, there's a lot of good, helpful information. This sort of teal bar at the top, our drop-down menus. From the drop-down menus, you can access our statutes, the Freedom of Information law regulations, our advisory opinions, case law summaries. We have, if there's anything new and exciting in the world of open government, we put that right here on our banners, our front home page. There's a contact us page. So again, it's a good place to like play around with. And if you've heard rumblings about any updates to the open government statutes and want to find out, there's a good chance you're going to find something right here on our homepage. I just added this real quick because so often I've made reference to the part of our website that contains my training information. So once this program's done, it's being recorded right now. Once this program's done and all the previous programs that I've done just like this, I record them and then I ask our IT staff to post them on the committee's YouTube page. And in addition, the slides, which mostly the ones that were available through the WebEx link that you got when you registered for this, it's almost going to be exactly the same. But I did make a few changes and I asked our IT staff to update the website for that as well. So the PowerPoints that I'm using today, I requested be posted here. What you'll do is the same page that I just showed you a little while ago, opengovernment.ny.gov. You're going to scroll down just a little bit and you're going to see this section of the page. And then in the lower right-hand corner, it says view training materials and recordings. Click on that button. It will bring you to our YouTube page. It will bring you, to a link to our YouTube page, as well as the most up-to-date slides, training slides. So hopefully you'll find that useful. Open meetings law is codified also in Public Officers Law. Article 7 was passed in 1976. And the law states that it is essential that public business be performed in an open and public manner and that citizens be fully aware of and be able to observe the performance of public officials. Citizens have the right to attend and listen to the deliberations and decisions that go into the making of public policy. I just want to step, one thing else I forgot is, as we go along, you're welcome to type your questions into the chat feature. And at the end of the program, I will go into the chat feature and try to answer any questions that come up during the program. So feel free to put them in there. Unfortunately, I'm not great at multitasking in terms of going back and forth between chat and the PowerPoint. So I just found it moves a little bit more smoothly if I do it this way. So back to the intent, citizens have the right to attend and listen to the deliberations and decisions that go into the making of public policy. So the public have the right to go to the meetings in person, and they must be able to see and hear either their elected officials or people that have been appointed to public bodies that have a substantial say in how government works. Public does not have the right to participate in these meetings. They don't have the right to speak. They don't have the right to provide public comment. That's something that many public bodies voluntarily offer, but it is not something that is statutorily required under the open meetings law at a regular meeting of a public body. It is voluntary on the part of most public bodies at a meeting. Hearings are different. Hearings are governed by other statutes that are outside the scope of our advisory jurisdiction. Here, I'm just talking about meetings of public bodies, and public comment, public participation is not a statutory requirement. When we talk about the citizens' rights under the open meetings law, it's not just about having the right to be there when the decision makers vote. They have the right to see how the decisions are made. So all the deliberations, the discussions that lead up to the decision, the ultimate decision should also be occurring in that public setting. What is a public body? So the open meetings law doesn't obviously govern all government meetings. We have meetings every day as public employees. Not all of them are subject to the open meetings law. Open meetings law governs meetings of public bodies. So what is that? It's an entity, it's a collective, so to speak, for which a quorum is required in order to conduct public business. So quorum meaning a majority of the total membership. This public body has to consist of 2 or more members, has to be performing a governmental function either for the state or for a department of the state or for a public corporation. which includes local governments such as counties, cities, towns, and villages. So maybe your county legislature, county board of supervisors, city council, town boards, village boards of trustees. In addition, it includes school boards, public library boards. Then you go on to like sewer boards, water districts, all those entities that serve as governing bodies of government agencies. In addition to the full board, full public body, any committee or subcommittee of a public body is also a public body subject to the open meetings law. So if you have a 15-member city council, for example, the city council is a public body subject to the open meetings law, but the 5-member finance committee is also a public body subject to the open meetings law. So if that committee is made up entirely or primarily of members of the public body, it becomes its own public body subject to the requirements of the open meetings law. In addition to those sort of traditional entities that we think of as governing bodies of our municipalities and state governments, there are other entities that are created in general by state statute to perform a necessary function in the governmental decision-making process. Also has to be a situation where a quorum is required in order to conduct public business and consists of 2 or more members. So here we have situations such as the Committee on Open Government. We're not a governing body, but we were created in 1974 by the Freedom of Information Law, and we believe ourselves to be an entity created or appointed to perform a necessary function in the decision-making process. So when the legislature, for example, the governor, is considering recommendations for amendments to the open government statutes, hopefully they're taking into consideration the annual report that the Committee on Open Government is required by law to prepare and submit to them every year. There are other entities too, such as you might think of planning boards, zoning boards of appeals, ethics boards, board of assessment review. There are several other types of public bodies that are housed within our government that serve a necessary function in the government decision-making process that are considered public bodies that are sort of that non-traditional entity. When the law was amended, when the open meetings law was amended a couple of years ago, there was language that added that a necessary function in the decision-making process does not include just recommendation or guidance that is purely advisory and does not require further action by the state or the municipality. So if an entity is purely advisory, has no final decision-making authority, then the legislature has made clear that those types of purely advisory bodies are not subject to the open meetings law. Now here, let me clarify, sometimes people get a little confused and they sort of conflate 2 different concepts. Earlier, I mentioned how committees and subcommittees of a larger public body are subject to the open meetings law. So 15-member city council, 5-member finance committee. Often those committees are purely advisory, but the law requires any committee or subcommittee of a larger public body to be subject to the open meetings law, regardless of whether they're advisory or not. This last language really applies to situations such as maybe within your town or village, you have a Parks and Recreation Committee that brainstorms ideas for how to improve the parks and recreation in your municipality, and you come up with ideas and suggestions and you send them along to your town board. There are lots of entities where you gather input from your residents, students, business owners, but they don't have any final decision making, but you use that sort of group knowledge to come up with ideas to present to the decision makers. Those purely advisory bodies, those task force, are generally not considered by the statute to be public bodies that are required to comply with the open meetings law. They're, of course, surely welcome to do so, but are not required to. So before we dig into the basics there, I'm going to talk a little bit. I know this has been going on for so long now. It seems that perhaps it's old news, but I think it's important to distinguish and help everybody understand the requirements relating to in-person meetings and when video conferencing is permitted. The important thing to remember is that the legislature at this point has shown a clear preference for in-person meetings. Unless there's some sort of state of emergency that at this point doesn't exist anywhere at the statewide level that prevents people from meeting in person, then all meetings must have an in-person component. There is no such thing as a completely remote meeting in general at this point in time. No public body is allowed to have completely remote meetings at this time. There has to be an in-person component. In the spring of 2022, the governor signed legislation that expanded the use of video conferencing by public bodies, but only under limited circumstances. So pre-COVID, pre-pandemic, we had a way to use video conferencing where you may have multiple physical open locations. Perhaps, like for example, the Committee on Open Government, the people that serve on our committee live at different places in the state. So we would open our offices in Buffalo, Albany, and New York City. Our members were permitted to choose which location was most convenient for them, and the public was allowed to choose which location was most convenient for them. We opened up all three of those public locations to our members and to the public, and we connected them through the use of video conferencing. This is something that has been permitted for many years pre-pandemic. As long as the locations were included in the notice and open to the public, it was permitted. Then, of course, the pandemic hit, and we went to all these completely remote meetings. This provision expanded in a very limited way the use of video conferencing, where a member of the public is permitted to attend from a private location, a location that is not included in the meeting notice and that is not open to the public, but only if they are experiencing an extraordinary circumstance. And I'll explain what that means in just a minute, but for the purposes of right now, it was set to expire this past summer, but it was extended until July 1st of 2026. So it's still currently in place that members of a public body can attend from a private location under extraordinary circumstances if their public body has adopted policies or local law or resolution allowing them to do so. So what is an extraordinary circumstance? It is defined in the law as disability, illness, caregiving responsibility, or any other significant or unexpected factor or event which precludes the member's physical attendance at such meeting. In order to take advantage of this provision, a governing body of a municipality, such as like a county legislature, city council, town board, village board, they have to adopt a local law. If you're any other type of public body, like a school board or a library board of trustees, you had to pass a resolution. Any public body that wanted to take advantage of this provision had to have a public hearing first. Then they could either pass the local law or adopt a resolution. In addition, all public bodies have to establish written procedures, and those procedures have to be conspicuously posted on their website. So the procedures had to be consistent with the requirements that were added to the open meetings law through this provision. This provision states that a minimum number of members of the body must be present in person at a physical location in order to fill the public body's quorum requirement. So if you have a 5-member town board, in general, you need to have 3 members sitting in their seats at town hall. I mean, that's just an example. You can understand where there might be other situations, but in general, let's just go with the assumption that if you have a 5-member town board, in order to meet the quorum requirements, you have to have a majority of your membership present at physical locations that are open to the public. The one exception to this is if the extraordinary circumstance that one of your members is experiencing is a disability as defined by New York state law that renders the member unable to participate in person at the meeting. If that is the person's extraordinary circumstance, they are permitted to count, they can count towards a quorum even if they attend via video conferencing. But if you're participating, so this is just a summary, if you're participating from a physical location that's been properly noticed and is open to the in-person public attendance, you count towards a quorum. If you're video conferencing from a remote location that is not open to in-person public attendance, but you meet the disability criteria established by the amendment from 2023, that is the only time someone attending remotely from a private location would count towards a quorum. Who can participate in the meeting, though? Members who are participating from a physical location that's been properly noticed and open to in-person public attendance, those people are like just the regular town board member that shows up to town hall sitting in their seats. They can participate in the meeting. In addition, any member who's video conferencing from a remote location due to an extraordinary circumstance can fully participate and vote, but only if a quorum has otherwise been met. So they can't satisfy the quorum, but if you have a quorum, then the members who are attending from that remote location can fully participate. All right, notice of a meeting. Notice has to include the date, time, and location, and if appropriate, instructions for virtual attendance. Notice must be given prior to every meeting to the media. This does not mean that the public body has to purchase a legal notice. Just means that the media, your local media, has to be put on notice that a meeting is going to occur. The notice has to be placed in a designated physical location, like a bulletin board or something like that, where the public has access. And if your agency or if your public body or the agency in which your public body is housed has an active website, it has to be posted on that website. When does notice need to be given? At least 72 hours prior to a meeting scheduled, at least 1 week in advance. So if you have a regularly scheduled meeting, a meeting that's been scheduled at least 1 week in advance, you have to give 72 hours notice. If for some reason you need to have a meeting less than 1 week from the date you realize it, if you need to have a meeting in 2 or 3 days, for example, notice must be given to the extent practicable at a reasonable time prior to the meeting. The open meetings law itself doesn't say when you're allowed to have meetings on short notice, but the courts have weighed in a number of times, and they've suggested that in general, a public body should only be having a meeting, should only be scheduling a meeting less than a week in advance and providing less than 72 hours notice if they actually need to do so. For example, if some harm would be caused by them waiting. The open meetings law also states that if you're using that extraordinary circumstances video conferencing where your member is attending from a private location, the public notice for the meeting has to inform the public that that type of video conferencing will be used. The notice has to say where the public can view and or participate in that meeting, because if you're allowing your members to attend via video conferencing, you also have to allow the public to attend via video conferencing. The notice should also include a statement that where the records that are scheduled to be discussed will be posted or available. And of course, as always, it has to identify the physical location where the public can attend. I just mentioned that the provision relating to records scheduled to be discussed, where that should be included in the notice, or at least the where you can find the records scheduled to be discussed should be included in the notice. About 3 years ago, the law was amended to require that records scheduled to be discussed during an open meeting must be made available upon request and posted online at least 24 hours before the meeting if the agency maintains a regularly and routinely updated website and utilizes the high-speed internet connection. So essentially, if your agency, if your municipality, whatever the case may be, has a website that it updates on a regular basis, any records that you plan to discuss during your meeting should be posted online at least 24 hours before the meeting. This obligation has been in existence since February 2012, the obligation to make these records available to the public. The amendment that occurred in 2021 simply placed a 24-hour minimum time frame. It used to just be prior to or at the meeting. Now it's 24 hours before. What types of records are we talking about? Any proposed resolutions, laws, rules, regulations, policies, or any amendments to those items? And any records or portions of records that would be available under the Freedom of Information Law that the public body plans to discuss in open session. Agency may, but is not required to spend additional money to implement this section, and it does not apply to records discussed in executive session. Only applies to records that are going to be discussed in open session. Minutes. Minutes of an open meeting must include a record or summary of all motions, proposals, resolutions, or any other matter formally voted upon and the votes thereon. If extraordinary circumstances video conferencing is used, it must include which, if any, members participated remotely. A public body is only required to prepare minutes of executive session if they vote in executive session, if action is taken in executive session. Otherwise, if the public body merely deliberates in executive session, but does not vote or does not vote until it comes back into open session, there are no separate minutes of that executive session necessary. Those minutes must be prepared and available to the public within 2 weeks of an open session and 1 week for an executive session. And it does not matter whether the minutes have been approved or not. There are some public bodies that only meet once a month, once every couple of months, maybe only a couple times a year. So they are not always able to approve minutes in any sort of timely manner. And that is completely irrelevant to whether the minutes must be made available to the public. The minutes have to be prepared within 2 weeks of an open session, and they have to be made available to the public once they are prepared. The law was amended in the fall of 2021 to require any agency that maintains a website and uses a high-speed internet connection to post their meeting minutes on their website within 2 weeks of the date of the meeting or 1 week of an executive session. The law states that for purposes of this subdivision, so purposes of this posting requirement, an unabridged video or audio recording or an unabridged written transcript can be deemed to be meeting minutes. But this does not mean that a public body is not still required to prepare minutes. Public body still has to prepare minutes, even if they have an audio or video recording, even if they have a written transcript. They still need to prepare minutes that comply with the statutory requirements of the open meetings law. That record or summary of all motions, proposals, and any other matter formally voted upon and the vote thereon. Those separate meeting minutes still need to be prepared. It's just that if a public body would prefer to post the recording or post the transcript in lieu of posting open meeting or the minutes, they can do so. Recordings. Any meeting of a public body that is open to the public shall be open to being photographed, broadcast, webcast, or otherwise recorded and or transmitted by audio or video means. An agency is not obligated to record unless a member is participating remotely under the extraordinary circumstances provision. An agency can establish reasonable rules to limit disruption and interference. We have model rules available on our website if any public body would like to look to those. But essentially, if someone shows up like with their smartphone or small recording device, they don't need the public body's permission. They don't even need to let the public body know that they're doing it. They have the right to record any portion of an open meeting. They're not permitted to record executive session. They're just the open portion of the meeting. What is an executive session? Executive session is defined in the open meetings law as a portion of an open meeting that is not open to the public. An executive session should never occur prior to, the start of, or completely separate from an open meeting. In order to enter executive session, a public body must make a motion during a noticed, scheduled open meeting. So you have the meeting, you put out the notice, you invite the public to attend. Once they're in the door, then the public body is permitted to make a motion to enter into executive session. Then they can vote upon the motion, and then if it's a vote, if the motion to enter executive session is approved, they can then go into executive session. That motion by statute must identify the area or areas that they plan to discuss in executive session. In addition to what the statute requires, a significant amount of case law on the subject that states that those motions to enter into executive session must be sufficiently detailed to reflect to fellow board members and to the public that the body is going into executive session for a proper purpose. So, for example, a public body should never just say, I move to go enter into executive session to discuss personnel matters and pending litigation. That is not sufficient according to the existing case law, and there's a ton of it. A motion to enter into executive session for personnel matters is one of the worst things the courts are going to want to see. You need to be more specific as a public body. I'm not advising that you need to identify the people that you plan to discuss, but for example, if you were discussing resumes that you've received to fill a position, say that. Say, move to enter into executive session to discuss the applications we've received to fill this identified position. Perhaps you say, I move to go into executive session to discuss possible disciplinary action and the employment history of a particular person. You don't need to identify the particular person. You just need to say it's a particular person. If you're going to discuss litigation, you need to, in most cases, unless significant harm will be caused by doing so, identify the litigation that you plan to discuss. And please keep in mind with litigation, you're going into executive session to discuss actual litigation strategy. The law does not permit a public body to go into executive session to discuss matters that may lead to litigation. It's the actual litigation itself. What we have up on the screen right now is all of the reasons you're allowed to go into executive session. If you don't find it on this list, essentially that means that something that the conversation has to occur in public. Oftentimes we see, for example, public bodies attempting to move into executive session to discuss contract negotiations. That's nowhere on here. The only type of contract that is in here is collective bargaining negotiations under the New York State Taylor Law, the Article 14 of the New York State Civil Service Law. Collective bargaining negotiations can occur or be discussed in executive session, but there's nothing in here that would allow a public body to discuss general contract negotiations in executive session. The second mechanism for meeting behind closed doors is an exemption. So executive session is a part of an open meeting where an exemption is completely separate and not subject to the open meetings law. If one of these exemption applies and the open meetings law does not apply at all, it's as if the open meetings law does not exist. The three exemptions are judicial or quasi-judicial proceedings, except for proceedings of the Public Service Commission and zoning boards of appeals. So this could be like, for example, some ethics boards have hearings, quasi-judicial proceedings. Some boards of assessment reviews have quasi-judicial proceedings. So some of these entities, if they're having that type of hearing, quasi-judicial proceeding, that proceeding would be exempt from the requirements of the open meetings law. Deliberations of political committees conferences, and caucuses are exempt from the requirements of the open meetings law. So, for example, if your elected town board consists of 3 Democrats and 2 Republicans, even though those 3 Democrats represent a quorum of the board, they are permitted to meet whenever they want, wherever they want, without providing notice to the public, without inviting the public into the discussion. They're allowed to talk about whatever they want. They can't make any decisions, they can't vote, but they're permitted to talk about whatever they want. The third exemption is when a public body is meeting to discuss any matter made confidential by federal or state law. Different agencies might have things that come up that are very specific to them, but I would say that probably the most common example that runs across all public bodies is when that public body wants to meet with its legal representation, its attorney, for the purpose of requesting and receiving legal advice. That gathering, where that conversation is covered by the attorney-client privilege, which is made confidential by New York State statute. Under the Civil Practice Law and Rules, there is a codified version of the attorney-client privilege. So if your public body is meeting with its attorneys for the purpose of requesting and receiving legal advice, that conversation can occur completely exempt from the open meetings law. Please keep in mind, of course, that the mere presence of an attorney is not enough to assert this exemption, to take advantage of this exemption. The attorney has to be playing an active role in providing that legal advice. Once the attorney's active role is complete and the public body wants to go on to deliberate and make decisions, the exemption is over. The public body has to then go back and wait until they, if they're in the middle of a meeting, they have to go back into open session. If they're having a gathering that was completely standalone from their regular meetings, then they have to wait to have those deliberations, discussions, and make decisions until their next regularly scheduled meeting. I mentioned this morning, but I'll mention it again for probably several people that weren't on this morning. Last spring, there was an amendment to not the open meetings law and the freedom of information law, but actually public authorities law. So public authorities are what I sort of refer to as these quasi-governmental entities, and they have them at the state level and at the local level. So there was amendments to the public officers law, clarifying that all these authorities are subject to both FOIL and the open meetings law. But the amendment also states that to the extent practicable, these authorities have to stream all of their open meetings and public hearings on their website in real time, and they have to post video recordings of all open meetings and public hearings on their website within 5 business days of the meeting or hearing, and maintain the recordings for a period of not less than 5 years. So again, this doesn't apply to agencies like it doesn't apply to a state agency under the New York State Executive like the Department of State, but it would apply, for example, to the New York State Dormitory Authority. It would apply to the Metropolitan Transit Authority. It applies to local development corporations that are created under public authority law. It doesn't apply to counties, cities, towns, villages, or school districts. It does apply to any authority created pursuant to the authority under New York State Public Authorities Law. Non-compliance and enforcement. The Committee on Open Government does not have enforcement authority. Enforcement is through the initiation of a Civil Practice Law and Rules Article 78 proceeding. The court has the authority to award costs and attorney's fees if the court determines that the violation of the open meetings law was substantial enough. Any actions taken during the meeting that was the subject of the litigation, or as a result of meetings that were the subject of the litigation, the court could determine to invalidate those actions. However, the law clarifies that actions should not be invalidated on mere technical violations. I'll note that I've seen some case law that indicates that, for example, a failure to post record schedule to be discussed within the 24-hour time limit has generally been found only to be a technical violation if the public body has otherwise complied with the open meetings law. That's just something that I've noticed in the past year or so. Court can also require you to take training from our office, so that's a fun thing that you have to look forward to if you have open meetings law problems. So I'm going to just shut down my share screen, and then I'm going to go back to turn on my little video here, and I'm going to go to the chat feature and start peeking through the chat and see what kind of questions we might have that I can answer for you. Oh goodness, I always have a hard time with this little screen. It's being difficult. All right, let's see. Just scrambling through some of the intro things that we talked about. First question I see is, what if a full public library board is meeting for training and no business is being discussed or voted on? So this is a good question, is that there are sometimes situations in which a public body is not actually gathering to conduct public business. So for example, if I go to a program that's hosted by NICOM or the Association of Towns or the New York State School Boards Association or something of that nature, and a quorum of a particular public body is sitting in the audience listening to me speak, that's fine. That's not a meeting of the public body. They're not there to collectively discuss public business. So it's fine for a public body, even if no one else is there. If the purpose of the gathering is to receive training and not, for example, not to discuss public business, not to collectively engage in discussions or decision-making about either your library, your school district, your municipality, whatever the case may be, if it's just to receive training or something similar to that, maybe it's a social gathering, maybe it's your annual 4th of July gathering and you're all invited, that's fine. There's nothing wrong. It doesn't mean you can't all be in the same room. It just means you just have to refrain from engaging in discussions relating to your public business. Someone says, so every single subcommittee of a public body needs to live stream every meeting and post that for the public. So live streaming is only an obligation under certain circumstances. Live streaming is only an obligation if you're a state agency. If you're housed within a state agency, there's an obligation to live stream your meetings. Live streaming is required if you're a public authority. So when I talked about committees and subcommittees, their public bodies have to comply with the open meetings law. Yes, every single committee and subcommittee of a public body is required to comply with the open meetings law, but live streaming your meetings is not always a requirement. Live streaming is only a requirement under certain circumstances. All right, so someone I think is a little confused about that distinction with committees and advisory bodies. Okay. Again, let's go back to that concept of the 15-member city council. Any committee or subcommittee made up entirely or primarily of members of that city council. So if you have a 5-member finance committee and every member of that finance committee is a member of the city council, it is a public body, and that's just end of inquiry. You don't ask any other questions. It doesn't matter if they're purely advisory or not. In fact, most committees are just purely advisory. In general, most committees might make recommendations to the full public body, but have no final decision-making authority. So that's not the relevant question. If you are a committee or subcommittee made up of members of the larger public body, you are always 100% going to be subject to the open meetings law, and you don't ask the advisory body question. The advisory body question comes in if you're something sort of standalone. If you are again, like a Parks and Rec task force and you're made up of residents of the community and business owners, if you're maybe a pedestrian and bicycle safety committee, and again, you don't have any final decision-making authority. The people that serve on these committees are made up of residents that are just volunteering, not elected, from the community, and they're coming up with ideas and suggestions, and they pass that advice along to the decision makers. That's when the question matters as to whether they're advisory or not. If they are purely advisory and serve no state statutory function, then they're not likely going to be considered public bodies subject to the open meetings law. Someone asked, is live streaming? I think I just answered that. Not sure. The second question is, when is live streaming required? Which I think we just mentioned, we just went over that. Live streaming is required for public bodies housed by state agencies. It's required for any public authorities. Making video conferencing available to the public is required if you are allowing one of your members to participate in your meeting through extraordinary circumstances video conferencing. So there's a little bit of a distinction between video conferencing and live streaming, because live streaming is really kind of a one-way street, where video conferencing tends to be a two-way street. So live streaming, really, there's only sort of two circumstances. State agencies and public authorities have to live stream. Video conferencing is required when you're making video conferencing available to the public is required when you are allowing one of your members to participate via video conferencing. If your entire meeting, if you are a town board and your entire town board is in person at town hall, there's no online access, no live streaming, no video conferencing is going to be required. Next question. In this context of meeting quorum, what does properly noticed mean? I think maybe this question came in before I talked about notice, because I had a whole section on what notice is required. Does remote participation by members for reasons other than disability require the adoption of resolution by the body to amend rules? If a public body wants to allow its members to participate remotely from a private location due to an extraordinary circumstance, and that could be disability, illness, caregiving responsibility, or other significant or unexpected factor that prevents them from appearing in person, they have to either pass a local law through a local government, or they have to adopt a resolution. Yes, slides have already been made available to you through WebEx, and I mentioned at the beginning that they're going to be posted on the website. Our votes in executive session are required to be roll call. So that term isn't really used. There has to be a record of how every member voted. Anytime there is a vote, whether it's an open session or executive session, there has to be a record of how every member voted. Roll call is not a term that's used in the open meetings law. Regarding FOIL records that are required to be posted, is it only those relating to something being discussed or proposed? It's records scheduled to be discussed during an open meeting. That's the language of the statute. If the records are scheduled to be discussed, they have to be made available. The records used to be in executive session need to be posted. Nope. Does requirement for public authorities regarding video conferencing mean? I'm going to skip over this question and have that person contact me directly. It's talking about land banks and bids. All I can tell you, public authorities are required to live stream. Does a public body inform if they are audio taping, and does it have to be posted on their website? Must a public body inform? No, public body does not have to inform if they're recording their meetings. You should just, if you're at an open meeting, you should assume there's a possibility that you're being recorded. No, it does not have to be posted on the website, or an audio tape does not have to be posted on the website. If there's video conferencing, if you're offering video conferencing due to the extraordinary circumstance, that recording has to be posted of that website. But if it's just an audio tape, for example, the town clerk audio tapes the meeting for purposes of preparing minutes easier later when she goes home, or he or she goes home. But there's no obligation for that to be posted on the website, but it is a record subject to FOIL and to the record retention and disposition schedule. I think I've already, Rachel, I think I already answered this about, do you think the committees of public bodies could be considered advisory? We've already, I kind of dug into this already a little bit. Are votes held in executive session valid on their own? Or does the body come out of executive session and then vote on what was discussed in executive session? If it was a properly held executive session, they're permitted to vote on the topic. The body can vote in executive session. I think school boards have rules that apply to them that are where it's governed by education law, but under the open meetings law, there's no prohibition on voting in executive session, except you can't vote to appropriate public money in executive session. But even if you vote in executive session, there has to be a record. You have to prepare minutes. So often public bodies just choose to vote in open session because they know there's going to be a record of it anyway. Some local bodies use a consent agenda, and would the items being voted on be required to be discussed in public prior to the votes? The open meetings law does not address this. Rachel, you're bringing up the advice. There may be amendments to the statute. I guess I'm just only speaking to what the law requires right now. The way the law is phrased right now is that any committee or subcommittee of a public body is a public body subject to the open meetings law, regardless of advisory status. Honestly, I've never heard of a committee that is not advisory, so it seems not. I don't know what the purpose of making any changes to that would be. If teleconference video conferencing is used by an outside participant, such as an offsite auditor making a presentation, but members are otherwise in person, would the body be exempt from the recording and posting? All of the rules regarding participation relate to participation by a member of the public body. So if you're not a member of the public body, you can participate any way you want, whether it's by teleconference or video conference. There's no restrictions on how non-members of the public body participate. Is it advisable to make notes of an executive session if you feel like the board is overstepping their authority and the reason why they went into executive session in the first place? What is the recourse? If you are a member of a public body, anytime you take notes, you need to keep in mind that those notes, you are creating records that are subject to FOIL. So that's what I'm going to tell you in terms of whether it's appropriate to take notes of an executive session. What you do as a member of a public body, if you don't feel that the executive sessions are appropriate, that's something you need to work out with your own sort of ethical standards. And the recourse for noncompliance with the open meetings law is an Article 78 proceeding in state Supreme Court. Is it allowed if they want to attend a meeting virtually because they are snowbirds and live outside the area for multiple months a year? A member of a public body cannot attend using the extraordinary circumstances provision because they're a snowbird. That's not an extraordinary circumstance. Being a snowbird is not an extraordinary circumstance. However, if they want to attend from their winter home, and if they are willing to provide the location of either their winter home or a publicly accessible place nearby, they want to open that location and include the address in the public notice and state the public is welcome to attend from that secondary location. that's when they can attend, when they're snowbirds. Can public bodies who are not in a union go into executive session to discuss but not vote on a personnel handbook? No, I'm not really sure. I'm not really understanding the reference to who are not in a union. But discussing a personnel handbook is not an appropriate subject for executive session in any circumstance. If a member has a business trip, is that considered an extraordinary circumstance? In my opinion, it is not, but you all need to make your own decisions on that. The language is significant or unexpected factor. I just don't think a business trip fits those definitions, but there's not really been any litigation on the topic, so we don't have much to work with. What if a vote is taken in a closed caucus? You can't vote in caucus, or it doesn't count. So I guess that's the short answer, is that there is no authority for a public body to vote during an exempt political caucus. I don't have any other questions coming in. So I thank you all for joining me today. This is being recorded. It's going to get posted on the website. The new slides, I put in a request today for both the Freedom of Information Law training materials and the Open Meetings Law materials to get posted up on the website. That's the place that I pointed you to. And if you have any follow-up questions about something that I discussed today, please feel to shoot me a note. And I appreciate you all for joining me today. Thank you very much.